All right, good morning. This is the labor and employment piece of the morning conference, and I'm Jeff Risch. I'm in the labor and employment group with SmithAmundsen, and to the right of me, Michael Hughes, my partner. To the left of me, Beverly Alfon, my partner, and Mike, little.
I'm Mike Hughes. Jeff's going to, I think, lead off with some topics. I'll be chiming in, but we'll speak on some other topics a little bit later in the presentation. But again, Mike Hughes. I'm also a partner in the Labor and Employment Group.
Hi, everybody. Bev Alfon, also a partner in the Labor and Employment Group, and I will be doing the same. So we're really going to sort of work off each other. Some of us will lead on some topics, but for sure try to give each other some perspective to provide to you. Thanks, Jeff.
So with the labor and employment piece, I mean, we've got, of course, the fallout of the 2020 election and where that leads us into 2021 with the Biden administration. We're going to talk a bit about that. Near and dear to me is project labor agreements, responsible bidder ordinances and requirements, as well as prevailing wage. I'm going to try and do justice to those three topics: PLAs, responsible bidder, and prevailing wage. Some of that regulates the public work. Some of it regulates the private work, especially with PLAs. And I'm going to talk a little bit about joint employer relationships and liabilities and what's going on in Illinois, unique to Illinois, and what is percolating on a federal level. And then Mike Hughes is going to give, this is where it gets scary. You're going to buckle up. The PRO Act. There's a lot of interesting things in the PRO Act. And if just a little bit gets through the Senate in 2021, it's a new game, a new dawn, a new age, a new era for employers. Particularly with an emphasis on unions, union organizing, and union rights going forward. And then Beverly also will talk a little bit about COVID. I know Matt Horn, he's awesome, he does a great job. There's some things unique with the employment relationship that we want to make sure that is covered this morning. So with that in mind, I'm going to jump into my bucket of topics. I focus a lot on PLAs, project labor agreements, and it seems like it's a weekly call where I'm explaining to a client or a prospect that yes, a project labor agreement so far generally are found to be lawful. And they can be legally implemented not only in private work, but also traditional public work. So for the most part, and through case law and years of legal challenges, they've generally been upheld. Now and then, you'll get a court to invalidate a project labor agreement on private and or public. That does come up, but it's unique facts. It's the right judge on the right day. So generally speaking, they're legal. They're lawful. What's interesting is that under the Bush administration, I think 43, right? 43, number 43. Under the Bush administration, there was an executive order that basically precluded and made efforts to try and persuade contractors to not implement project labor agreements. The Obama administration in 2008, one of its first acts was to invalidate and override that Bush executive order. Interestingly, the Trump administration did not override Obama's executive order. There was no prohibition or any persuasion to not utilize project labor agreements from the executive branch under the Trump administration. So there's not I would I would have bet everything I owned that if Trump would have done that, one of the first acts of President Biden would have been to invalidate the Trump executive order. But he didn't have to. There was one executive order he did not have to sign because Trump didn't do anything about it. How that played out under the Trump years and how that's playing out under the Biden administration in Illinois specifically is I am already seeing project labor agreements being utilized by local units of government in 2021. It's, I don't know, there's like something is in the water. We are already seeing local counties, park districts, school districts adopt a resolution that would require and mandate a project labor agreement on that work. We're seeing from a private sector, I wouldn't say it's increasing, but it does exist. And from what I'm hearing in Washington, D.C. these days, is that there may be even a greater emphasis than ever before with project labor agreements, financial incentives to utilize the project labor agreement, both on private and public work, from the Biden administration. So that is my long-winded way of trying to explain that in Illinois, local units of government seem to be gravitating towards the usage, the mandate, the requirement that a construction project that they control, that local unit of government controls, would require union-only participation. That's what a project labor agreement really is. The trade unions coming together, working with the local government, and requiring that a particular collective bargaining agreement or various collective bargaining agreements are to be utilized by all workers and contractors that are working under that project labor agreement. From a private development perspective, I see it, but it's not as, it hasn't been as popular and as common as it has been and what we're seeing from a local government perspective. So, and I want to see what Mike and I know Mike's done a lot of work in this space. I know Beverly has as well. But my bottom line is, if you are if you are non-union, this is really this is concerning, especially if you have made your mark performing public work for the local county, local village, local municipality. You need to be in control, knowledgeable, keeping up with what's going on in your literally in your backyard, and you may be required sooner than later to, in order to perform that work that you've historically performed, to sign up with the trade union, with the corresponding trade union. If you are union, you're not in the clear. It could still be a problem. A lot of union contractors don't realize that their collective bargaining agreement may not be, and in my experience, because people only call me when there's a controversy, when there's a problem, they're not signatory to the collective bargaining agreement that's been adopted under the project labor agreement. So they're under the wrong, they've got a CBA. They've got the CBA, they comply with the CBA. They know their CBA, but the CBA that they're operating under is not the right collective bargaining agreement. That is a cluster when it does come up, and it has come up in the past. So with project labor agreements, you know, I think they're just going to grow in popularity here, Mike, and, you know, if you,
yeah, and I would add that Jeff's right, that these are popping up in municipalities, in county boards are voting on these things. And if you're operating in certain counties, it behooves you as a contractor or a general contractor to keep tabs on what the agenda is going to be for your county boards or municipal boards if you do a lot of work there. Because it's not like these things are getting a lot of press when they're put on the agenda or up for debate. You really need to know what's going on there to make sure that if it is on the agenda, that you can go to that meeting and or submit evidence or submit your position to voice your opposition to a project labor agreement ordinance that might be on the docket for your county or your other municipality. And Jeff's right, these things do cause problems. If you're a signatory with one labor union that might not be included in the overall project labor agreement in that municipality, to get work on that job, you're going to have to become signatory also to a different collective bargaining agreement with a different union. It's not going to absolve you from having to pay into the pension and other benefits that you're already paying for your workers under one collective bargaining agreement. You may also then have to pay into a different pension fund, and other different funds under the collective bargaining agreement that you have to operate under for that particular project, to no benefit of your employees, who are never going to become vested in those benefits at all. So you're paying double, and to no benefit of your employees, only for the benefit of the labor union pension funds that are signatory with the project labor agreement. And at a time when in Illinois, our public pension system is so underfunded, for a lot of these municipalities to put these ordinances in place, which is basically turning into a bailout for the private sector pension funds that are underfunded, seems really counterproductive.
I would add to that, I think, Mike, what you're speaking to, too, is that with these project labor agreements, you run into a problem. It particularly is a problem for contractors when there is work that is disputed. Who covers that scope of work? You're hearing from one union, this is our work, this is always our work. And then you find out the project labor agreement has given that work to someone else. It becomes a battle. You're told from one union, you should sign up with us. If you want that work for this large public utility, we're the ones who have it. The other union doesn't have a seat at the table. Great news, because you find out the competitor signed up with the wrong union. But then along comes the competitor who's either wisened up or has enough political muscle to get back into that scope to get under that project labor agreement. It's one of those issues that contractors are getting blindsided by. And certainly, I don't think we can downplay, we shouldn't ignore that these unions are very much on top of these meetings, these public works when they're out there. I was just reading about, I think it was the Vista School District. The room was packed with the parents of students of that school district, all armed with union t-shirts, pro-union t-shirts. They wanted it known. Not only did their kids go to that school, but they had family that worked for the unions. So again, I'm just echoing what we've talked about here, but certainly it will, as Mike said, behoove you to stay on top of that, because the unions certainly are.
Yeah, and I see it. We've seen it play out with what's been going on in Illinois for a number of years. The Rauner administration, of course, actually there was an executive order trying to not enforce PLAs and discourage the PLAs, and then that reversed under the Pritzker administration. I just see what's going on in Washington with President Biden, good, bad, or otherwise, surrounding himself with really strong, powerful, influential union leaders in the administration, particularly at the board, at the labor board, at the Department of Labor, and I'm just anticipating what may be coming down with the encouragement and the incentives for PLAs, and how the courts are going to reconcile that, because they have been fairly favorable with a PLA. So I think it's just sort of an avalanche that I'm anticipating. So if you're a union, be aware, because it does impact you. And if you're non-union, be aware, because signing up with the PLA, it's not for that project. It's just not, that's not how this system has worked traditionally in our experience. So buyer beware. Turning and pivoting a little bit to responsible bidder. Again, responsible bidder, that term, it sounds good, it makes you feel good, and there's a lot of good things with responsible bidder. We want contractors that know what the heck they're doing the work. We can't have fly-by-night outfits performing construction work. It's a problem. But here's the rub, and here's where it becomes concerning to contractors, and that is there's a component of responsible bidder is, again, on the state, if you're doing work for the state of Illinois, you have to be a responsible bidder. And there's requirements. Most of the requirements make a lot of sense. You got to be legit. You got to be economically viable. You have to have insurance. You can't be doing illegal stuff and getting away with it and continue to do work with the state. Local units of government have adopted their own, similar to the project labor agreements, they adopt their own responsible bidder ordinance. And within the responsible bidder ordinance or law, one requirement that always trips up contractors is participation in USDOL apprenticeship training. You've heard me, you hear me talk. I continue to talk about this because it's something that just continues to be a problem. And where it lies is what is participation? What does that mean? And so as a friendly reminder, because we're seeing responsible bidder play out, there's talk in Springfield to make responsible bidder a requirement no matter where you're performing prevailing wage work, public work. So we might not even have to wait for the local unit of government to adopt their own responsible bidder ordinance. I know that's something that the trade unions have pushed in Springfield in years prior, and they have, I would think they have a pretty good shot of getting something like that passed in 2021. So the responsible bidder, getting back to what it is and why it's important, is the participation in U.S. Department of Labor apprenticeship training. How do you show participation? Because that's always the question. How do you show participation? There's 3 general ways to show participation, in my humble opinion. But you're not going to be able to Google or go to your favorite search engine and say, what is participation in apprenticeship training? There's no definition. I don't think that is a mistake. I think that was intentional, because who decides what participation is? Well, the entity or the individual that's controlling the purse, that's controlling the money, the public body. So participation, however, in my experience, has come through generally demonstrating one of 3 things. One, you're signatory to a trade union, and that trade union has USDOL apprenticeship training, and you're contributing to an apprenticeship training fund. That is, in most circles, participation. The next way is, well, what if I'm not signatory to a trade union? I don't have the signatory status. I'm not contributing into the apprenticeship training trust fund established through a union. Membership in an association. I have a membership. I have standing. I am participating through membership dollars and contributions to an association, to an actual entity that sponsors its own USDOL training programs. Now, these training programs, whether you're union or non-union, they have to be programs that your worker is engaged in, your workers are engaged in. So it can't just be any program. If you've got painters, it's got to be a painting program. You got operators, it's got to be an operator program. And then the third way is, suppose a contractor, an entity, could form its own and sponsor and create its own program directly with the USDOL. I don't need an association. I don't need a union. I'll do it myself. That's difficult. It's not easy, but it's possible. Now, where it becomes more controversial and where the lawyers get involved is show me if the public body, particularly the local unit of government, says, show me the workers that are going to be performing work on my project. Show me that they graduated from a DOL apprenticeship program. Show me that they're, or show me that you have individuals actively in a program. Well, the problem with that is there's not always access to those programs. It's not like it's a 24/7, 365 program. The program's only up and running certain times, and some employers just don't have the need. I don't have the need to send anyone into apprenticeship program. My workers are journey workers. They're experienced. They've been doing this for 30 years. I just don't have the need. It gets a little weird, and it gets a little intense when you have a public body demanding that level of participation, and you're looking at them like they have three heads because you're asking for something that is just impossible. So I don't know if you had any further comment on that, Mike or Beverly.
I think that sums it up pretty good.
All right. It's one of those. It's just similar to a PLA. I'm just seeing responsible bidder requirements included in the bid specifications. And responsible bidder, unlike a PLA, would be public work. I have not seen a responsible bidder requirement in any sort of private development or private work whatsoever. That's more of a public works issue. Speaking of public works, last but not least, prevailing wage. We can't do this conference without mentioning prevailing wage. Now, under the Biden administration, I'm anticipating possible more expansion and encouragement of what would fall under Davis-Bacon and related acts, similar to the PLA, encouraging it, ramping up investigation and audit. If you're going to get audited for a Davis-Bacon prevailing wage project, go out and buy a lotto ticket because you got some weird luck, bad luck or good luck. The chances of you getting audited on a Davis-Bacon project historically fairly relatively low. Maybe under the Obama, and I didn't see that under the Obama administration. I didn't see a major ramp up in Davis-Bacon prevailing wage audit and enforcement. Just didn't see it. Maybe under the Biden administration, we could see more of a ramp up with the audit and investigation. Illinois prevailing wage is a completely different animal than Davis-Bacon and related acts prevailing wage, federal prevailing wage. Illinois prevailing wage is it's its own, it's its own animal, and you either know it or you don't know it. The latest and greatest from the Illinois Department of Labor with Illinois prevailing wage is the electronic submission. On September 1st, remember they started out, it was going to be April 1st, and they kept pushing the electronic submission of the certified transcript of payroll into electronic system and database that was that's controlled and managed by the Illinois Department of Labor. And they went through training and education to make sure everybody understood that you have to submit it. And then they came out with I don't know if it's not a press release, but they went public in August saying you have to have electronic submissions starting September 1st, no exceptions. So, if you are performing prevailing wage work, whether it's the state of Illinois, doing work for the state of Illinois, or the local unit of government, or you're doing private work, you're doing purely private work, and unbeknownst to everyone, there's some public money being pushed by the local unit of government or the state. Once you realize and once you're put on notice that it's PW, you have to submit the certified transcript of payroll electronically. Now, I also would caution anyone to keep a paper copy of any information and data that they're submitting. I don't know where this goes. I'm not in control of the electronic database. Weird things happen with electronic data. So I'm encouraging all of my clients to always keep a paper copy of anything that you submit. Have it near and dear to you, lock and key, fireproof system, because you never know where you're going to need that in order to go through and help through an audit. If you're not submitting the certified transcript of payroll electronically for whatever reason, you're in technical violation of the Act. And a technical violation of the Act could create a notice of formal violation. You get 2 formal notices of violation, and now you're subject to potential debarment from the state. Another wrinkle with prevailing wage that I want to share today, and I think this is pretty cool. I get questions a lot about what would be covered, the scope of work. I understand it's a public works project. I understand I'm doing work for the local school district. I understand that we're laboring, we're working, we're doing work. But there are components of the work that nobody's getting their hands dirty. Whether it's inspection or testing, there's no repair being performed. There's no installation being performed. There's no quote-unquote construction that's going on. It's more like an inspection, a testing, a calibration, and whether or not certain work would not fall under the scope of the Illinois Prevailing Wage Act. A strategy that I've adopted recently is there's certain things that I know because I do prevailing wage work. That's prevailing wage. There's no way around it. But if we get into some gray areas, and we can get into some gray areas with construction, right? Sending the Illinois Department of Labor a Freedom of Information Act request. They have to respond to the Freedom of Information Act request. They have a legal obligation to respond to it. And in responding to it, the inquiry is, show me any assessment, opinion, correspondence, audit, finding, violation relating to this work. And when they come back with, we don't have anything, and then I can do a dive into the case law, then I can explain to the client through a legal memorandum, legal opinion letter, that Illinois, the Department of Labor doesn't have anything on this work. Not surprisingly, there's no case law or attorney general opinion related to this work. And in the analysis of the statute, it's my humble opinion that this little part of the work would not fall under the scope of the Illinois Prevailing Wage Act. That's pretty good. I think it's pretty cool. And not saying I'm right. I could be wrong. But it gives the client confidence. It gives them a tool. It gives them, I believe, it gives them some good faith defense built into what they're doing. I don't know, Mike.
It certainly shows that you're taking your legal obligations into account, and you're not just running people out there willy-nilly and not concerned with whether or not that type of work falls under the prevailing wage statute. So it shows that you put thought into it, that you attempted to comply with your legal obligations, even if in the end you end up being the test case for this type of work being covered under prevailing wage. You give yourself the ability to maybe lessen some of the impact of that, but to show that you were in good faith attempting to comply with your legal obligations.
And you remind what you just said, Mike. Yeah, it absolutely. And but that goes with also being able to show that when I am doing work that is clearly falling under the Prevailing Wage Act, and I'm paying it,
Right.
and I'm certifying it, and I'm recording the time, and I'm recording the information that I need to record and submitting it electronically. That's the good stuff.
Right.
Because you're not looking to you're not looking to evade the obligations. Hey, if I don't have to pay prevailing wage for this part of the project, why would I pay why would I'm just going to throw money away? It doesn't make any sense, particularly for the taxpayer. Okay, so that was a big bucket that I wanted to go over, the PLA's responsible bidder prevailing wage. And I also wanted to just briefly, and I'll probably lean on Mike a lot for this next segment is joint employer. This is where what happened under the Trump administration, particularly their interpretation of joint employer under the Fair Labor Standards Act, minimum wage, overtime purposes, is decidedly different than what the Obama administration looked and what they offered, as well as what I anticipate the Biden administration is going to be pushing in the months to come. And then we've got the Illinois Department of Labor, and this is new, this is fresh, proposing their own unique rule of joint employment. And I'll tell you, and Mike, he testified down in Springfield on this. I don't know if it did any good.
We'll see. We'll see.
I don't think it did. I don't know. We'll see.
I think it was a pro forma hearing.
But you've got the Illinois Department of Labor coming out with its own definition of joint employer that makes it very difficult for construction contractors and GCs. It makes it very, very difficult. And what we're talking about, joint employer, so everyone's following along. Why do we care? What are you talking about? The sins of two separate employers. There's nothing per se illegal about being a joint employer. It's just once you're deemed a joint employer with another legal entity. So I'm an employer. I've got my own employees. I've got another legal entity that I'm probably contracting with, right? A subcontractor, a lower tier contractor. The sins, the mistakes, the unlawful pay practices of one employer becomes the liability of another employer because they're deemed to be joint employers. For wage and I'm really focused on wage and hour purposes because the Trump administration came out with a rule in, I think it was this time last year, where joint employer was, long and short of it, harder, just more difficult to establish joint employment status, joint employment relationships, particularly in construction. And I would also include staffing relationships with that, those vertical relationships,
right.
Not to get too wonky. Mm-hmm. But in the construction industry, very difficult to show joint employment relationships. A federal judge in New York, I think the Southern District, invalidated most of what the Trump DOL did with joint employment and reestablished what they called the traditional economic reality test or the economic dependency test, which still, I mean, it's not a foregone conclusion
right.
that joint employment relationships exist in the construction industry. especially if the construction contractors are bona fide corporations or LLCs or legal entities that have their own payroll and their own employees. And
Right.
you're just subcontracting out to a bona fide third-party entity, right, Mike?
Exactly. And the current economic realities test gives contractors, and this, this isn't only related to construction contractors, but gives employers a fighting chance to show that, no, that I'm not a joint employer with the agency that's either supplying labor or that we're subcontracting work out to.
Yeah. So despite, I mean, the way I look at it is, despite the Trump's administration's attempt to make it a tougher standard to show joint employment liability, even assuming that's invalidated completely, right, and it's over, then you still have an economic reality test, and the mumbo jumbo with that is it's not easy to show joint employment liabilities and relationships in the construction industry, generally speaking.
Mm-hmm.
Now, the Biden administration might come out and say that the economic realities is not enough, and they might want to fight and advocate for a looser standard. That's not what I'm here today to discuss. I'm here to discuss good old Illinois, the land of Lincoln. And their proposal is, I mean, they're going to make the economic realities test like a day at Disney. This is going to be tough, especially for construction industry employers. So the test that the Illinois Department of Labor has come out with, and I don't see this, it's a regulation. It's not statute, it's a regulation. And I don't see anything that is going to derail this.
Right.
Do you, Mike?
I don't.
All right. The factors, and not one factor is more important than the other, but some of the factors include the employee's work is to the benefit of the alleged joint employer. So if you think about that in the construction industry, when is not a subcontractor's employee's work integral to the construction project?
Right.
All right. Another factor, the work performed by the employee is integral, so sort of like the benefit, goes to the benefit of another employer, is integral to another employer. Again, in the construction industry, I read those standards, and I what the kids say, cringe. I think the kids still say cringe.
I don't know if they say that anymore.
Okay, they do? They do. All right, I'm not cool. All right. Another factor is the alleged joint employer has direct or indirect control or influence of the other employee's terms or conditions of employment, including, this is where it gets weird, the employee's schedule or the quality of work.
Right.
I don't know any upper tier contractor that's not looking and inspecting and ensuring that the quality of work or coordinating schedules.
Right, and it's direct or indirect.
I know.
So it doesn't even have to be exercised in fact.
Yeah. It could be a reservation in a contract.
Exactly. So if you have the reservation in your contract that we can inspect the quality of that work, you have that. You're ticking a box.
Painful.
Yeah.
It's painful. The alleged joint employer owns or leases the premises where the work is performed
And this
or
can
provides
pull
tools and
developers
materials.
in as well.
Oh, yeah,
as joint employers, and not just the general contractor, but the owner of the project.
Yep.
Potentially can be found under this test as a joint employer as well.
And then the final factor, you don't have to have all factors, just one. I mean, it's the circumstances of the particular case will decide this. The alleged joint employer has direct or indirect control over the other joint employer's operations through, there you go, Mike, contractual obligations, shared joint management, direct or indirect ownership interests, or economic dependence. So it's
And it raises a presumption that you are the joint employer, and then it says, oh, you can try and get out of it, but in order to, well, first, all those things that Jeff listed, it says if any two are there, you are going to be likely presumed to be a joint employer. And so even if you hire, let's say you're a manufacturer, I know that we're talking, well, let's say at your offices, you hire a plumber to come fix your sink. It's for your benefit. You have a say over the quality of the work, and it's taking place on your premises. You're likely, under this test, potentially going to be found to be a joint employer with that plumbing company for that plumber's wages and any other terms and conditions of employment. If you want to get out of that presumption, you have to show that you are completely separate, have no say over any of the terms and conditions of that employment, and have no financial interests with the other company at all. So you have to show total and complete separation on the backside to try and overcome this presumption. It's a nearly impossible test.
So pivoting to, the sort of a bottom line here, the joint employment in the construction industry really it emphasizes that you need to know who you're getting in bed with on these projects. You need to know you're only as good as your weakest employee or your weakest supervisor. You're only as good with the joint employer definition that's proposed by the Illinois Department of Labor that I see taking effect this year, this construction season. You're only as good as your subcontractors and the contractors, or if I'm a subcontractor, I guess my general contractor or my upper tier contractor, because it goes both ways. It goes both ways. So if your contractors are not meeting their legal obligations, specifically minimum wage and overtime, which can be, it happens to the best of them. Not recording time properly, things fall through the cracks. You could be on the hook, and I'm anticipating that particularly larger general contractors and upper tier contractors are going to maybe be brought into claims, legal claims, controversies,
Prevailing wage claims.
and lawsuits, prevailing wage. Yep. So, trying to navigate these questions. Okay, so we are giving out the presentation. We'll be following up the session here with in an email, and all the presentation, the slides, the material will be handed out. So I'm going to pivot to this PRO Act, Mike, and yeah, I mean this is exhausting. So
Yeah. And how much time do we have? Half an hour. Okay. So there's a lot here. This PRO Act, as Jeff said, it's a piece of federal legislation. He said it at the beginning when he introduced it a little bit, that it contains some interesting provisions. I would say they're very interesting. And it relates to union rights. And that's exactly right. Regardless of how this is trying to be sold, it is not, from what I see, an act that is attempting to better employee rights. It's an act that is attempting to better union rights. And really, it is the conglomeration of every piece of legislation, every pet project, every political issue that the labor unions have attempted to enact, either through case law at the NLRB, through agency rulemaking at the NLRB, or other legislation, largely of which has failed. Every one of those items that they've tried to get through those means in the past 15 years is packed in to this PRO Act. And its PRO is the acronym for Protecting the Right to Organize Act. It is like I said, a sweeping piece of legislation that would amend the National Labor Relations Act and the Labor Management Relations Act in many, many ways. It would upend the procedures and the methods that practitioners, employers, labor unions have been operating under since the 40s in many situations. This piece of legislation has passed the U.S. House of Representatives. It has not been brought to the floor of the Senate. Now that the Senate is, the Senate's agenda will be controlled by the Democratic leadership, it's likely that either this entire act or bits and pieces of it find their way into other legislation. But knowing what is all in here is, again, pretty sweeping and contains a lot of not only interesting but very scary things for employers. There's not a ton of time, and I want to save some time for Beverly's topics as well. So I'm going to move through some of the items that are, I think, of most importance to construction contractors that really tip the scales in favor of labor unions, and really to do four things: make it much easier and simpler for unions to organize construction companies and any other companies so they can gain more members, to remove any leverage and tactics that employers may have in resisting union organizing, to remove any restrictions on unions in the tactics that they have. Right now, the unions have to play by a certain set of rules when it comes to picketing, messaging, and striking, things like that. It removes a lot of the restrictions that have been placed on unions in order to level the playing field. And it gives the unions a hammer to enforce all of this against employers and to really hold a lot of these provisions over an employer's head so that the employer will bend to the union's will, whether that's in an organizing attempt or in negotiations for contract terms. So, with all that said, what's in it? Well, it changes the way that organizing is done and that elections are held. Currently, if a union files a petition to organize a company or petition to hold an election at a company, the employer is considered a party to that case at the NLRB. No longer would an employer be considered a party to any representation case at the NLRB, not only for an election that would be filed to bring in a union, but no longer would an employer even have the right to file its own petition to decertify a union, even if in the certain time window that you're given, every single one of the employees in the bargaining unit comes to you and signs something saying, we no longer want the union. Not only would it remove the employer's right to withdraw recognition from the union based on that information, but it also would remove the employer's right to even go to the labor board and file a petition based on that information for an election. Only the employees or only the union would have party standing to file a petition or to participate as a party in any of those cases. The amendments would codify a lot of the quickie ambush election rules that we're really currently operating under, so shortening the time period from when a union files a petition for an election to when that election has to happen, and some other short circuits of the election process. But also, interestingly, would codify the use of micro units. So currently, if a union wants to try and organize a company or at least some portion of the employees at a company, it has to show a community of interest within a certain bargaining unit. And the employer then, as a party to that case, can say, well, you ought to be including these other people here too. They are under the same supervision. They are subject to the same terms and conditions of employment. If you're going to have a bargaining unit, it ought to include this other group as well. This would codify the ability for the union to pick off small segments of an employer. Let's say people who work on second shift, even though they're doing the same thing as people on the first shift work, or people who perform a slightly different type of work than another segment of the employees, even though, again, they're subject to the same terms and conditions of employment, same supervision, everything. It would allow the union to get a foothold in a company by picking off a small portion that it knows it can win an election in. And currently, employers have the ability to say that that unit is not appropriate. You'd have that ability, but it changes the standard to make it very difficult for employers to challenge the unit that is petitioned for by the union. It also decreases who are considered supervisors under the National Labor Relations Act, who are not entitled to the protections of the Act, who cannot be in collective bargaining units. This would allow more people to be considered employees and not supervisors by removing some of the things that currently is in the definition of a supervisor and would require the alleged supervisor to have to be exercising those supervisory duties for a majority of their work time to be considered a supervisor. I'm not going to talk about the joint employer provisions of this act because it really follows largely along. It's not as drastic as the Illinois joint employer definition, but it's along those lines and will make it much easier for two sets of employers to be considered joint employers, which means you'd have to have a bargaining unit with the other employer. You'd have to sit at the table with this group of jointly employed employees, even though they're not your employees, and bargain. You'll also be bound to the unfair labor practices that might be committed by the alleged joint employer. So I'm not going to belabor that, but that is in there as well. As well as independent contractor, it makes it easier for employees that you are currently considered independent contractors to say no, they're actually your employees, and it includes penalties even if you inadvertently categorize someone as an independent contractor. And so I'll talk about some of the stiff penalties that this act also would include. It also would remove the employer's right to hold mandatory meetings with its employees to discuss unionizing. And so currently, if a union is trying to organize a company has the right to say, employees, we're going to have a meeting, and you have to come. It's on the clock. Listen to us give a presentation with respect to your rights under the National Labor Relations Act, what it would mean to be a member of the union, how paying dues works, all those things that are important pieces of information for employees to have in deciding whether or not they want to vote a union in. It would remove that ability for you to hold a mandatory meeting. You can only hold voluntary meetings. It would mandate that you'd have to let employees use your electronic email and other electronic means to organize against you. It would allow the union to decide, and not the employer would have no say as to the method of the election. Currently, it's a bedrock of the National Labor Relations Act for secret ballot elections. During COVID, they've moved almost exclusively to mail ballot elections, but this amendment would give the union its say in whether they want to have a mail ballot election, whether they want to have an electronic election, whether they would have it an in-person election at the employer's facility, or whether they would have an in-person election at some other facility, perhaps like the union hall. And this would give the employer no say in any of those points. And finally, you may remember the failed Employee Free Choice Act, which would have codified card check as a means for a union to come in. If they had over 50% of your employees sign union authorization cards, they would be certified as the labor union. That legislation never was passed. There's a modified version of that here. And what this would say is, if the union loses the election, then it could file an unfair labor practice charge against the company. And if the company is found to have committed an unfair labor practice that relates to the election, then one of two things happens. Either if it's found that affected the outcome of the election, the union, if it shows 50% plus one of cards, gets certified as the representative for the employees. If it's found not to have affected the outcome of the election is still tossed out and a new election happens. And interestingly, it allows the union to gather these authorization cards from the period they're considered valid if they're up to a year before the election, and continuing post-election, even after the union's lost, they can go try and get these 50% plus one authorization cards up to the point in time when the board would decide that an unfair labor practice had occurred. So you can imagine post-election organizing after a union loses, specifically a close election. In bargaining, so employers that do have a union, for initial contracts, it would require that you meet with the union within 10 days of the union being certified for bargaining purposes. It would, if after 90 days you don't have a contract finalized with the union, which I don't know, Jeff, have you ever seen a contract finalized in 90 days?
No, Fire River's negotiating it for you.
Yeah, so
They're getting it done within 90 days.
So if after 90 days there's no contract finalized, then the FMCS, Federal Mediation and Conciliation Service, comes in, and if they can't help out and mediate a full contract within the next 30 days, then the matter goes to what's called interest arbitration, which is an animal of public sector labor relations. But what happens is the union picks an arbitrator, the company picks an arbitrator, and there's a neutral arbitrator, and then they decide what the terms of your contract are. The things they're supposed to, under this law, look at are the employer's finances and its prospects, the employer's size, the employee's cost of living, the employee's ability to sustain their family on the wages that you are offering, and what other employers in the industry are paying.
On what other employers, the union, I mean, we don't get a lot of organizing in the construction industry.
Right.
We get some organizing in the construction industry. I mean, the unions have other tactics to try to pressure the contractor to sign, because the contractor wants the union off their front porch. They want harmony on a particular project. They're getting pressure from a general contractor or a developer or an owner or a public body. So they'll voluntarily sign whatever the union is telling them to sign, typically an 8F agreement. But this traditional organizing, I could see, I mean, we have had organizing in the construction industry.
Absolutely.
And if you were to organize, I've been at the negotiating table in those cases. The union just says, here's the area-wide agreement, sign it. And we say, whoa, we want this, we want that. And no, this is what you've got. So it will be interesting.
It will be interesting, and that's
if that component were to pass somehow.
Right.
Probably not necessarily the PRO Act. I think that's going to be a tough order for them.
It would still be unlawful in that situation. A union is not allowed in a 9A situation to say take it or leave it on this other contract we have in the area-wide. Good luck trying to show that they committed an unfair labor practice by doing so. That's what they will do. But in theory, that's unlawful for the union to say take it or leave it. Now, there's nothing that would prevent in that situation, and this is where it really affects a lot of union contractors. When they first see the PRO Act, they're saying, hey, fine, let's level the playing field. Let's get more people to be union contractors, and we're all working on the same deal. That's not necessarily what's going to happen, because if an employer gets organized under these, resists just signing on to an 8F agreement, an area-wide agreement, gets organized through these new, very simplified election processes, goes to negotiations and says, I'm not signing the area-wide agreement. I'll bargain with you in good faith over the terms. And after 90 days or 120 days, you don't have anything. Well, it's this arbitration panel that's going to decide your terms. And that might be less, might have maybe some more favorable terms than the full area-wide agreement. The area-wide agreements oftentimes contain Me Too provisions, and you're going to have, or most favored nations provisions, and it's going to cause a lot of problems there as well. But even if not, you may have a one-off contractor now who's signatory with the union, who's got better terms than the rest of the employers under the area-wide agreement.
Even work rules, even non-economics.
And I'm saying a lot of those things are going to be, and let's talk about the pension funds.
Yeah.
Is an arbitration panel going to say, yes, it's equitable for you to become a party to a pension fund that is underfunded to, like we've seen in some industries, 24% funded. And a lot of them are operating way in the red. It's not likely that a neutral arbitration panel is going to say that, yes, company, you're going to have to sign on to this failing pension fund. And now, instead they get a 401k plan. Now they're operating under that, and everybody else in the area-wide are paying into the pension fund. It's going to cause a lot of issues in the construction industry that way.
We got about 15 minutes.
Okay,
Mike.
I'm going to be real quick then. There's some other very interesting things. It would eliminate hot cargo agreements. And so right now, it would allow unions to insist in bargaining that the employers do not deal with any other company, handle their goods, accept deliveries from, work with suppliers of non-union companies. It would
make hot cargo agreements
lawful. Exactly, across the board. or right now they're not, and a union cannot bargain impasse over something like that. It would remove an employer's right to implement its last best and final offer if the parties reached impasse. It would require that you keep the status quo forever, basically. Forever, until the employees on their own went and filed a petition to decertify the union, because you couldn't withdraw recognition and you can't implement any terms and conditions. It removes any offensive lockout. So unions would have an expanded right to strike, and I'll talk about that in a second, but it would remove the employer's right to lock employees out unless the union had called the strike first. It would remove an employer's right to permanently replace economic strikers. So currently, if someone goes on, if a group of employees go on strike over economic terms, how much they're making, pension, things of that nature, they can be permanently replaced. It would remove that ability. It would, and a couple of things related specifically to the construction industry. All strikes would be legal. It would allow intermittent strikes, which are currently unlawful. So they could call a strike for Tuesday, come back Wednesday, strike on Thursday, strike on Friday, come back Monday, work Tuesday, strike on Wednesday. You wouldn't know what's going on. Currently, those types of intermittent strikes are unlawful. It would allow that to be a lawful tactic of the unions. It would allow partial strikes. So currently, if the bargaining unit's on strike, they're on strike. It would be up to certain employees if they wanted to cross to come back. But here, the union will be able to call a partial strike. Half the crew's going to be on strike today. The other half works. That's allowed. Slowdown strikes would be allowed and be lawful. Jurisdictional strikes would be allowed currently, and they would remove all the 10K procedures from the National Labor Relations Act. So if you're signatory with one contractor and one union, and another union comes and says, no, that's our work. Currently, if they strike or threaten to strike, that's an unfair labor practice. The labor board handles it. And one of the things that the labor board would look at in that situation is what's the employer preference, what's the employer's history to how they've assigned that work. That whole procedure would go away. They would be allowed to strike unless the parties, all of them, both unions and the employer, were members of the national plan, which is a procedure for deciding these jurisdictional issues. But that doesn't have the same employer preferences as part of the decision-making process there. The stronger union, in many cases, would prevail. And the big one for construction contractors, it would remove any restrictions on secondary strikes and secondary boycotts. So reserve gate systems, reserve time systems would be a thing of the past. The unions would be allowed to picket and strike against any contractor it wanted to, including the general contractor, including directly against the developer or owner, and not just informational picketing to the public, which it's allowed to do now for area standards, but it would be able to picket directly against, state it has a labor dispute with the general contractor, picket against it not only at the site of the job, but at your offices, at the developer's offices. It would be able to strike or picket anywhere, and it would remove the labor board's right to go get an injunction against such secondary picketing and boycotts. And then the last thing I'll talk about is it just increases substantially the remedies available to the unions and against employers for unfair labor practices. You'd have to post a notice in your job sites of the union's right, or of the employee's right to organize. If you don't, it's a $500 per day fine. If you are ordered to reinstate an employee with back pay because you're found to have terminated him based on union activity, or any other, or laid them off, improperly because of their union activity, there's no offset for back pay anymore. Currently, employees would have an obligation to mitigate their damages, and the employer wouldn't have to pay any amount that they earned somewhere else. You don't get that offset anymore. There is the ability to order front pay. So if the employee says, you know what, because it's such bad blood, I'm not coming back, even though I was found to have been unlawfully terminated, you maybe have to pay back pay, and now 2 years of front pay to that employee. There's 2 times liquidated damages, similar to the Fair Labor Standards Act. So not only are you paying them once, you have to pay them double. There's the provision for punitive damages to happen in certain circumstances. There would be mandatory injunctions to rehire and reinstate employees who are found or who are alleged to have been terminated for union activity. And it would be a mandatory injunction unless, and they've changed the standard, unless a court were to find no reasonable likelihood that the labor board would be able to show that it was an unlawful termination. So you'd be forced to, really, makes the labor board your HR department, determining whether or not you can lawfully terminate somebody. You'd have to bring them back, and then you'd have to pay them double damages if you deigned to try and contest or defend your decision. Civil fines of up to $50,000 for any unfair labor practice found. So if you're found to if you're ordered to reinstate someone, if you're ordered to bargain in good faith with the union, any unfair labor practice would carry up to a $50,000 fine. And if you don't comply with the order, it's a $10,000 per day fine for failing to comply with an order of the NLRB, and personal liability for directors and officers for those fines.
So just for sake of time and punt it over to Beverly, I do not believe that the PRO Act as passed by the House is going to see the light of day. Now, don't take me on my
I don't think all of it, absolutely not.
But this is strategy.
Right.
If they just get a little piece,
right,
and President Biden, good, bad, or otherwise, he's for all of this, but I think he would negotiate and accept just a sliver of this. And if they get a sliver of this, of all the things that Mike talked about, and you all should be just scared and petrified, if they get a sliver of it, it changes the ball game. I mean, it really does change labor relations in the United States. So, I know, Beverly, I know you had a couple other comments related to traditional labor.
Yeah, the only exclamation point I will add to that is that the PRO Act also would provide a private right of action for any unfair labor practice charges, which currently only an individual or labor organization can bring it before the board, before the labor board, but now this contemplates allowing them to literally make a federal case out of everything.
Even if, and specifically when the labor board dismisses it.
Right.
Yeah.
Right.
Yeah, it's not over.
Exactly. So that's the legislative end. Let's just briefly talk about what's going on at the labor board. The news was a flurry last night, this morning. We all know that President Biden did end up firing the NLRB's general counsel Peter Robb, staunch anti-union guy, was responsible really in his role to decide what cases to go after and which cases not to go after. It is an unprecedented move by a president. We don't know who the potential replacement will be, but I think we can expect that it's going to be somebody with strong union ties. The labor board itself right now is it's comprised of 3 Republican members. We have 1 vacancy, 1 Democrat. One of those positions is going to become vacant, one of the Republican seats, in August. So we may be looking at a Democratic majority as soon as August of 2021. But again, we'll see where this all ends up. I bring it up because I want to just at least mention that there is ongoing litigation before the labor board that involves Chicago's very own Scabby the Rat. We all know Scabby the Rat. Local 150, the operating engineers, has this matter pending before the board. The board invited friends of the court, so to speak, other organizations from the public, to come and brief and make their positions known while they try to decide whether or not the inflatable rats actually are more akin to picketing as opposed to just bannering. So that the idea is, does the rat, and let's assume there's some handbilling going on by some union members or representatives at the same time, does that equate to picketing? And why that matters, of course, is because secondary picketing that's focused on a neutral, who the union doesn't have a direct labor dispute with, is illegal. Local 150 is arguing it's the First Amendment right. They stay on public property. They get to say whatever they get to say. But of course, management side is saying the effect and the purpose is obviously directed to discourage people from coming in to patronize the neutral employer, from other businesses from doing business with them, and certainly is expected, and the expectation is that pressure is going to cause the neutral employer some harm. And so I just wanted to make sure that we're all aware that that's there, because I think it's possible a decision is going to get issued before we have that Democratic majority. If there is a victory, it may be short-lived. But just remember, it's not going to be as quick of a turnaround as we would expect, as the Labor Board would need a case with the proper facts in front of it to overturn it. So anyhow, stay tuned on that.
Yeah, under the Obama administration, that his board came in, it was in August, September, where they started, and then it wasn't until of 2009, and we didn't start seeing these cases, these picketing cases, until 2010.
Right.
The summer, early fall of 2010. So it takes
time.
A while.
It takes time. So Scabby the Rat, I think, is a great segue into disease and vaccines. Obviously, Matt Horn covered a lot with regard to COVID-19. I know that Dennis also covered a lot. So I'm going to focus on an issue that has been coming up more and more because we're hearing about it every day in the news: vaccines. Vaccines, the question I keep getting first and foremost is, can we require it? Can we mandate it? And legally, yes. I think we have a basis to say, yeah, we can. On December 16th, 2020, the EEOC issued guidance saying, yeah, an employer has a right to require that an employee does not pose a direct threat to the workplace as far as health and safety. So that would include a vaccination requirement. But what we really need to understand here, and I'm going through the legal part of it, we're going to get to the practical part of it.
You got like 3 minutes.
I got 3 minutes. So legally, all right, we're running through it. Legally, here's the deal. You can mandate it, but you have to be aware of the other restrictions, such as disability accommodations, religious, sincerely held religious beliefs, practices. These are things that, as in the normal course of an employment relationship, there might have to be an interactive process if you have an employee who is telling you they can't do it or they won't do it. What that's going to mean is going to depend on the context. I understand if you have an operating engineer who needs to be out in the field, how can I possibly accommodate this person by allowing them to continue to work without a mask, or without a vaccine in close quarters when that occurs? Remote work isn't an option. So this is a reminder regarding that. Remember that if you have union represented employees, you are going to have to bargain with the union if you want to mandate vaccines. I don't think there's any question about that. If you do, whether you have union or non-union employees, if you have employees who object to the vaccines and your policy of a mandated vaccination, you have to be mindful of the National Labor Relations Act. Section 7 protects that sort of objection, whether it's among themselves, to their managers, or if they're out there picketing to the public saying, we don't want to be forced to have these vaccinations. And so the follow-up question is, should you mandate? And I think the answer to that right now, the most prudent route to that is probably best to just strongly encourage. Don't forget, it was just over a month ago that the FDA allowed these authorized emergency use of these vaccinations from Pfizer, from Moderna. It was just over a month ago. We're waiting now for the Johnson & Johnson emergency use authorization. But over the last few weeks, we've gone from hearing about a massive vaccine rollout to no supplies. So with so much uncertainty about when and how these vaccines are going to become available.
And zombies.
Lots of anxiety.
Zombies.
Zombies?
Yeah,
Lots of zombies. I've heard
They
the
turn into
zombies and
I'm waiting for people to turn into
the
zombies.
microchips. Okay, yes, we've heard.
Am I the only one who's waiting for everyone to turn into zombies?
I think anyway, we can't ignore that these vaccines are being distributed under that emergency authorization. We don't really know the length of effectiveness yet. There's no real world data, no long-term data on how long they stay effective. So the point is, large employers like Walgreens, Ford, GM, even hospital systems, at this point, under an emergency authorization, they are not mandating these sort of vaccines because of that uncertainty. You can't ignore there are populations that really just don't trust it. And then there's also some concern about liability. You mandate that policy, they go get it, then there's an adverse reaction, some extreme adverse reaction. You know, is the employer going to be on the hook for it? We don't know. But anyway, we understand the eagerness. We all want to get back to figuring out what our new normal is going to be. But again, if you're going to do it, I think you're going to go for a strong encouragement, focusing on, vaccine education, really selling it to your employees, making sure that they have the information they need, and getting us to the point that we're all trying to get to.
Great. Yep. I agree with all that. So thanks, Bev.
Sure.
Thanks, Mike, and thanks for everyone participating. It was a little different this year. I wish we were at a steakhouse, but it just couldn't work. But thank you, and we will have the presentation, the material. You have our contact. Don't be a stranger. If there's anything we can help with, we're here to help. Have a great day.